Greetings from Edu Aspirants, our YouTube channel to ACE Academics, competitive exams, entrance exams, as also for enrichment of knowledge. In the series of our videos on India, in chapter 21, let us see Law and Justice video 5. Personal law. The people of India are of different religions and faith. They are governed by different sets of personal laws in respect to matters relating to family affairs, that is marriage, divorce, succession, adoption, wills and the likes. The subject matter of personal laws is relatable to entry 5 of list 3, concurrent list in the 7th schedule of the Constitution of India. You must remember this. And hence the Union Legislature, that is Parliament, and the state legislatures are also competent to make laws. The following laws relating to marriage and divorce have been codified in different enactments applicable to people of different religions. 1. The Converts Marriage Dissolution Act 1866. 2. The Divorce Act 1869. 3. The Indian Christian Marriage Act 1872. 4. The Qazis Act 1880. 5. The Anand Marriage Act 1909. 6. The Indian Succession Act 1925. 7. The Parsi Marriage and Divorce Act 1936. 8. The Dissolution of Muslim Marriage Act 1939. 9. The Special Marriages Act 1954. 10. The Hindu Marriage Act 1955. The Foreign Marriage Act 1969. And 12. The Muslim Women Protection of Rights on Divorce Act 1986. The Special Marriage Act 1954 provides for a special form of marriage, and the registration of such marriages extends to the whole of India. Persons governed by this act can specifically register marriage under the said act, even though they are of different religious faiths. The act also provides that the marriages under any other form can also be registered under it. Provisions relating to marriage and divorce of Christians are enshrined in the Indian Christian Marriage Act 1872 and Section 10 of the Indian Divorce Act 1869, under which the husband can seek divorce on grounds of adultery on the part of his wife, and the wife can seek divorce if the husband has converted to another religion and has married another woman or has been guilty of incestuous adultery, bigamy with adultery, marriage with another woman with adultery, rape, sodomy and bestiality, adultery coupled with such cruelty as without adultery would have entitled her to a divorce, which is a system of divorce created by the Roman Catholic Church equivalent to judicial separation on grounds of adultery, perverse practices, cruelty, and adultery coupled with desertion without reason for 2 years or more. In the Divorce Act 1869, amended through the Indian Divorce Amendment Act 2001, discriminatory provisions against women in the matter of divorce were removed and provision for dissolution of marriage by mutual consent was added. Section 41 amended to provide for alimony or maintenance and education of minor children be disposed of within 60 days. As regards Muslims, marriages are governed by Mohammedan law prevalent. The Parsi Marriage and Divorce Act 1936 governs the matrimonial relations of Parsis. The word Parsi is defined in the Act as a Parsi Zoroastrian. Every marriage as well as divorce under this Act is required to be registered in accordance with the procedure prescribed in the Act. Jews do not regard marriage as a civil contract but as a relation between two persons involving very sacred duties. Marriage can be dissolved through court on grounds of adultery or cruelty. Marriages among Parsis are monogamous. Adoption. Although there is no general law governing adoption, it is permitted by the Hindu Adoption and Maintenance Act 1956 amongst Hindus and by custom in a few insignificant categories of people. Adoption being a legal affiliation of a child, it is a subject of personal law. Muslims, Christians and Parsis have no adoption laws and have to approach the court under the Guardians and Wards Act 1870. They can take a child under the said Act only under foster care, wherein on attaining the age of 18, the child is free to break away and has no legal right of inheritance. Remember this. Foreigners have to approach the court under the aforesaid Act for adoption. The Muslim bloc recognizes that mother's right to custody of minor children is an absolute right. For how long? Even the father cannot deprive her of it unless misconduct is proven. The Shia school holds that mother's right ends when the child completes the age of 2. For girls, it is 7 years. Whereas the Hanafi school extends the period till the minor son has reached the age of 7 and till girls attain puberty. The Guardians and Wards Act 1890 mandates that father's right of guardianship is primary unless the father is found unfit. Maintenance. Obligation of a husband to maintain his wife arises out of the status of the marriage and forms a part of the personal law. Under the Code of Criminal Procedure 1973, right of maintenance exists not only to wife, dependent children, but also to indigent parents and divorced wives, and depends on husband having the means. Anand Marriage Amendment Act 2012. The Anand Marriage Act 1909 was enacted to remove doubts as to the validity of the marriage rights of the Sikhs called Anand, and it did not provide for the provisions of registration of marriages. However, while the Anand Marriage Amendment Act 2012, the Anand Marriage Act 1909 was amended to provide for registration of Anand marriages, commonly known as, we all know that, Anand Karaj. This brings us to the end of the 5th video on law and justice. See you with the next and the final video in some days. Please subscribe, like, share and do press the bell icon for updates. Keep revising, you will have questions from this. Thank you for viewing and best of luck.